welcome back to the GC channel. I'm your host, Orlando Casares, the president and founder of British Law International. If you're new with us, welcome. This is a channel especially for you, for the GCs and for in-house legal teams, and it's powered by general counsels. We'll be covering today some of the trendiest topics, things that keep you up at night, and we hope that you will find the next few minutes invaluable and very insightful. So follow us along. Bruce, as you know very well, and so do you, Sean, because we've already had previous meetings with you and Bruce. First Law International is a community of about 20,000 attorneys that are representing scores of clients worldwide in over 100 countries. And I don't know what the math is, but I would venture to say that just about everybody has a client or several that are concerned about what's happening in the UK. And I just thought it was very elucidating, Sean, because that was one of my questions on the concern side, where I'm going to go after Bruce, where the tendency to want to overregulate, and now, as you very clearly pointed out, overregulate too quickly because of the vacuum. And you want to create leadership, you want to provide the right narrative. And so you want to tell the world, hey, we fixed this problem. And I think in the rush of doing that, you could really hurt yourselves, right? So Bruce, to the FLI audience of 20,000 attorneys and their clients that need to hear from someone such as yourselves who are anchored so well in the UK, on the regulatory side, all the GDPR and contract, all those issues that attorneys have to grapple with on a daily basis. What would your message be? Are you saying, we've got troubles and we need to deal with them one by one? Or is this more like, hey, you know what? This is an easy phase. We'll transcend to it. And in no time, we'll have answers to all these queries.
I think the truth is somewhere between those 2 points. Contextually, the London Westminster government, the UK government, has taken an awful lot of control back, which was its desire from Westminster, from the European Union, insofar as it's originated from the European Union, because obviously the UK is still bound by things like the WTO treaty rules and a variety of other international treaties. So the first point is that taking back control doesn't necessarily mean that you take back as much control to change stuff as you might initially think. The second thing tied to that is change as a requirement to change. What is the impetus for making a change? You need to be responding to something or driving a change. And at the moment, the consultations that the government are doing are very much asking business, what would you like different in law and regulation? And an awful lot of the feedback that I'm hearing, Sean, I guess it's the same for you, but just hear if it's different, is basically around, please, no radical change. Why? Because change costs. Why? Because change makes things more difficult internationally. Our suppliers will have to have 2 sets of standards and so on. So generally, the direction is for incremental change, well-focused change, well-researched change in a number of areas. Now, where there is difference is where the government has got a stronger set agenda on developing things, but where it's on environmental or where it's on battery technology for vehicles, that is such an international context that it will need to do it jointly and advance things in that sense. So where I do see significant smaller change is probably around the regulatory and tax reform to develop the domestic economy, micro initiatives in terms of regions to get investment funding in other areas, and some other areas of business and employment law change, perhaps around human rights and so on. The areas that are perhaps more concerning, but they're basically where in-house lawyer, general counsel need to really focus, is about the quality of legislative change. The English Parliament has a relatively small lawmaking capacity in terms of its number of sitting days against the volume of legislation it can get through the stage process it works in between the primary and secondary reviewing houses. So the actual amount of primary law that can be made fast is relatively limited. However, an awful lot of the TCA powers in relation to the UK have given powers back to ministers to make laws directly with minimal consultation. And the government's majority means that it can push things through Parliament quickly which doesn't always mean that the quality of what's pushed through is as good as it could be. So the watch out for lawyers is watch the direction of travel, because when things do move, they may move quite fast, both in terms of the lawmaking and the implementation, and they may not always be as thoroughly considered as might have been if there had been a slower, more thorough process. So to sum up, macro picture, probably apart from the thematic areas, the core thematic areas that the government is messaging out well, will be, my guess, more sedate, more progressive change. There'll be some eye-catching gimmicks, but that's politics. So look at the substance underneath it. There's another red tape initiative going on here at the moment. One regulation in, one regulation out. That's been done several times before. We still have more regulation. So I think it's more about watching for the trends, watching for the niche initiatives, and watching for the things that have been put through quickly without enough consultation and may therefore have inadvertent bear traps in them. But would I panic about that environment? No. Would I think that the value of horizon scanning and close monitoring is more important, both for seeing opportunities and also for seeing things that might trip you up by accident? Yes.
It's interesting that you mentioned that in consultation with government, that the primary message from the business community is when they were asked, how would you like us to manage this process? They said, no change. And of course, the pundits are going to say, and Sean is laughing, the pundits are going to say, well, that's what we were trying to tell you a few years ago. But we are where we are. And I would have to agree with you, right? Change, especially radical change, is expensive because it creates paralysis, right? And that's why I was hoping that you address the FLI audience, both from the legal framework, because 20,000 attorneys, but also all of our clients, all the in-house GCs that are now scratching their heads, thinking, "Wow, what do I do? How do I walk through all the regulatory changes and updates?" And we know it specifically, the corporate law in particular was not very well detailed in the TCA, because again, it's like how do you undo 45 plus years of the previous marriage all overnight. Well, thank you for watching. If you would like to see more videos like this one, subscribe to the channel and press the notification button below so that you will be alerted when new videos come out. We hope that you've enjoyed it, and we look forward to the next one. And don't forget, you heard it here first.